How y'all doing today? Well, baby, if your name is Diddy, the cops, the feds, Homeland Security Investigations is teaching a master class in how to taint a jury. And baby, we not mad at them. Y'all, okay, listen, the legal docs have dropped. What is it? Well, prosecution, if you guys don't know, has issued their rebuttal to Diddy's insane bail proposal. We're going to get into the whole 30-page document. It is a lot of laughs. It is a lot of kikis. It's a lot of fun. But more importantly, Diddy is out of his mind. One, what did the feds uncover? That the children are working with him to give social media posts, not to say how much they love their dad, not to say they miss him, but to do what they can to taint the jury. Diddy's running his whole legal team, and everything you see his kids doing, Diddy is telling them everything to post. On top of that, Diddy is talking about permanently silencing witnesses that won't take the payoff. On top of that, he is running things in jail. On top of that, Diddy got to be the dumbest man alive, because some of these hijinks that the feds get into in these legal jocks, you just got to shake your head. I find it odd. And also, it is, remember we said with Diddy, it's one rule for us, another one for him and his ego. This man was doing all of this while he was requesting a gag order. This man was using prisoner phone minutes, right, to plant false narratives, plant media narratives, literally push their children out there to actually become one RICO charges. If you guys don't know, for people saying Diddy's still a loving dad, by getting his boys involved in this, trying to run interference for a criminal organization, he has literally ensured, hold on. Hey, I'm on live. Can I give you a call back? Okay, but I'm going to be on live for a minute. I'll give you a call back as soon as I can, though. Text me if it's important. Bye. Sorry, guys. Sorry, guys. Anyway, where was I? Oh, yeah. Dragon Diddy. One, you got your kids RICO charges, right? Because now they're a part of the criminal conspiracy, the criminal organization. Christian, Justin, Quincy. Let's look for that in the superseding. They are officially part of Diddy's minions, okay? Two, you are literally out here making sure you're never going to come out on bail. Three, this shows the type of liar Diddy is. I'm a big thing that once somebody shows you who they are, believe them, right? Diddy, and we're about to get into the legal documents in a second, just waiting for a few more of y'all to come in, right? So Diddy, hold on, y'all. Black Letter Law has a thing. She said he's probably giving everyone hell by calling them over and over again like a little pest all the time. There's nothing more stressful than continuously getting calls all day from someone in custody. But all jokes aside, right? When Diddy tries to get public sympathy, when the Diddy sympathizers, and there are a lot of them out there, try to let us know what's going on, you have to remember Diddy showed us who he is over and over and over. Think about it, right? For one, right? Cassie was suing him. He knows what Cassie knew about him. He knows what he did to Cassie. Not only was he out there antagonizing her at BET Awards, putting her name in award ceremony speeches when she knew what she did to her. Talk, Cassie, it's all love. Not only was he making songs on his love album about she's the one that got away. Not only, but when we found out what he did to Cassie, he then posted online, oh my God, enough is enough. These horrible things. What did he say? I did not do any of these horrible things I'm accused of. And I said, yeah, Diddy, I know how to speak English too. Did you do any of the things you're accused of? Whether or not they're horrible, that's up to your opinion, my opinion. But did you do anything? Diddy has shown over and over and over again that he will lie bold-faced while he's doing another thing. Diddy was saying he can't wait for the truth to come out and all this other stuff, and going on his whole media campaign why he was silencing and paying off witnesses thinking he was about to get out of it. Diddy is in jail, had his lawyers post up actual motion. There needs to be a gag order. I can't get a fair trial. The victims are allowed to say what really happened to them. Think about what Diddy said. What was in that motion? I can't get a fair trial if these witnesses are allowed to speak their truth. So I want you to force the witnesses to be quiet. I want you to force the federal government to be quiet. I want you to force everything to be silent because I need a fair trial. And they're talking to media and they're planning stories. And there were some idiots that fell for that mess. You need to stop Diddy, this and that. And what did we find out? While Diddy was doing all that, he also was running his RICO organization of fear, intimidation, and all that stuff. He was running it from the jail. Diddy wanted everyone to be quiet so he could run his megalomaniac dirtbag campaign to literally cover the playing field. You know what else I think? Remember when those boys jumped on Ray J? Did Diddy tell him to do that? Because now we got to think Diddy is controlling his kids at all times. They cannot be trusted. They are compromised. They can be compromised because they love their daddy, but they are compromised. So whenever you see them do anything, we just need to roll their eyes and be like, nice try, Diddy. Nice try indeed. But honestly, this goes into it. Anyway, let's get into these full court transcripts. They also have the phone tap transcripts. Also, Althea also said, hold on. She said, and Diddy can't be controlled. This is black letter law. States that he can't be controlled. I know his lawyers told him not to talk to anybody while in jail. Oh, they did more than that. Do you know when that, you know what? Let's get into these court documents. Hold on, y'all. Let's just get into the court documents really quick. We're going to go through them section by section. I'm going to make it as entertaining and amusing as possible. We're also going to learn a little law. So let's get into this. Diddy is a megalomaniac idiot. And again, he's running the same play. Even the way his kids posted tributes to Kim, because that was the anniversary of her death, but all the videos were tributes to their daddy. Say dad, dad, say dad, dad. And Kim literally playing with Justin. It's really disturbing what he has those kids doing. And I guess at the end of the day, you can see Diddy's control of those kids, because how are you the sons of billionaires? You're 30, 33, and 26 respectively. How are you the sons of billionaires? And literally, you have not invested in Bitcoin. You don't got any outside investments. Y'all don't have any projects going on. That's how destructive Diddy was. Diddy just didn't stop his artist's bag. He made his children, even his grown adult boys, completely dependent on him. Because why aren't the sons of billionaires? Why is Diddy was the only money coming in when you had opportunity? But if you think about it, every single time his kids came up with something, Christian had that one song that he got a little bit of emotion off of, could have gone far. Diddy looked like he squashed that. Quincy, he could have been an actor. Did he squash that? Justin could have been a college graduate. He could have been an accountant. He could have been a business manager. He might have even played football. I don't know. They take him models to the 3 Apples High. Maybe they take him football players too. He put a squash to all that too. If you want to know the details why, please see the former videos. Okay, let's get into this really quick. This is the government's amazing opposition to Diddy's bail hearing. And guess what? The government went one step further. They said, excuse me, you know that we don't even have to have this bail hearing. You know that, right? You know, Your Honor, that you have the power to squash all this. Let's see if they even get the bail hearing. They're opposing even the bail hearing. Shout out also to Donna Burke and also Liz King. Congratulations on that new job. But Donna Burke, thank you so much for the super chat. You are appreciated. Okay, let's get into this. This is the United States of America. He said, send the cops and the feds and kids to come get me. If you can't, listen, they sent everybody. The United States of America versus Sean Diddy Combs. Now, I know some of y'all don't think it's possible. We do have to say that Diddy is going to try his best to be released by any means possible. If y'all think that Diddy will not see if he can't buy a pardon from either Biden going out or Trump coming in, I don't know what to tell y'all. This is a man that's running a RICO organization to the judge. Do you think that he is thinking humbly? Do you think he's thinking it's not his place? Now, I'm not saying either president is going to grant the pardon, but he is going to approach for a pardon. And just for you guys to know, you do not need to be convicted of a crime to get a presidential pardon. President can pardon you at any time from day one or day, I don't know, 365 times 4. On top of that, you don't even need to have charges pressed against you. All you need to do is commit something that is classified as criminal under the federal penal code, and you are eligible for, you can shoot someone in the street before the cops even pick you up. The president can make a call and say they are pardoned, let them go. The presidential pardon powers are vast and wide, even though, I don't know, he better pray that Biden and Trump think that he's one of the good ones. He better pray that they think he's one of the good ones, even though Biden, who knows what's going on there. And Trump, I think Trump feels like he's already done enough outreach to the Black community. I don't think that Trump thinks he needs to do anything else. And I do think that now, maybe a couple of years ago, Diddy given 100 million would have been a lot. But now 50 million, that's small potatoes when you talk about the type of money that might be able to sway either Biden administration or Trump administrations. But maybe one of Diddy's billionaire friends will put in a word. I know some people said Diddy's down with the Democrats. I just want to say this. When you get into that echelon of money, they all the same group. They all go to the same country club. They all eat together. Like, I can understand on the street, we're like, oh, Democrat, Republican, ah. But y'all realize when you get into that level of money, it's like playing cards. They all go to the same country club. They all send their kids to the same school. They all go to the same events. They're not as antagonistic as it would lead you to believe. I'm being serious, but whatever. That's just my opinion. Let's move on. All right. Let's go to, who is this? The United States of America versus Sean Combs, a.k.a. Puff Daddy, a.k.a. P. Diddy, a.k.a. Diddy, a.k.a. PD, a.k.a. Love. Now, let me tell you something. Nobody throws shade like the federal government. The federal government also hit us with a table of contents. They did the indictment and the defendant's arrest, the defendant's remand. They hit us with the applicable law, the discussion. The court should reject the defendant's attempt to reopen the bail hearing based on the same information he presented to Judge Carter. This is actually huge because the federal government is saying he does not have the right for another bail hearing. Your Honor, based off of what we know, you don't even need to give him another bail hearing. Let him go back up to that appellate court till they can say no, because I believe appellate court are supposed to review it de novo, which means they're not questioning the judge's reasoning. They're questioning whether the judge followed the applicable law and procedure. So if I find you guilty, right, they're not going to go back and retry the facts. They're going to say, well, did the judge follow the statute of limitations, the rules of evidence, blah, 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 blah. He did? Okay, well, that's fine. So they're literally looking for whether you made a procedural mistake, not whether your reasoning was faulty or wrong. And Diddy knows that if he goes up to the appellate court, it will be rejected because what the judge did was procedurally correct, okay? B, the court should reject the defendant's request to reopen the bail hearing because the defendant disagrees with the government's use of the term victim. Again, that is Diddy being a megalomaniac, thinking he is still calling all the shots. Oh, like that's not what a victim is. Diddy, a victim is anybody you talked to, touched, knew, loved, hated, harassed, was friends with, broke bread, or broke a bottle over their head. That's a victim, Diddy. Is that good enough? Okay, Your Honor. That's what they're saying. Reject it. The defendant's contacts with witnesses demonstrate the threat he possesses to the integrity of these proceedings. I know that's right. The defendant cannot rely on Section 3142I for his release. I think that's Section 3142I. I think that's saying that you need to be released so you can prepare for trial. He's trying to say that by being in a detention center with thousands of other inmates, it deprives them of his right to prepare for a free trial. Now, I know the government's going to rip them apart on that, and it was bold AF to even use that. So 3 subsection A, the defendant has continued his efforts to obstruct justice. We get into that. That's the juicy part. The defendant is a danger to others. I would say he is a danger to others, his children. Is he a danger to himself? No. Okay. The defendant continues to pose a risk of flight. I know that's right. The defendant's new proposed bail package is insufficient. And you know why it's insufficient? I was having this conversation with my girlfriend the other day. When you put up a bail package, you need to put up so much it makes you hurt. See, everybody's saying that Diddy is now worth 400 million. That is not true. I don't even think, and don't get me wrong, these are all huge numbers. So, I'm just talking about from an analytical point of view, not like, oh, I would love to have 100 million. I don't even think Diddy's worth 100 million. Maybe at most, if you add in the Soar Island houses, 120, 130 million. Now, I know that's a lot of money, right? However, Diddy only has 50 million liquid assets. The other stuff is either locked in house equity or it's locked in stock and stuff. And anybody knows anything about house equity and stocks, technically it's money, but if you need to sell quickly, you're maybe going to get 2/3 of that money. But more importantly, the bail package has to hurt. So when you do it, would you walk away from a lifetime in jail if you only had to give up 10% of what you owed? 10% of what you had? Of course you would. 20%, 30%. Baby, I would give up 80% of everything I own as opposed to going to jail, right? But just the fact that Diddy was only able to offer up 50 million, it shows how much he's really worth, okay? Why is that important? Well, Diddy got 11 kids and he got 11 lawsuits. So when you get into that, Diddy's money is sinking really fast. On top of that, these legal teams are costing him estimated, and this was before trial, an estimated $180,000 a week. And that was before trial. But anyway, let's keep going. All right. So we just went through the table of contents. You guys, buckle up. This is going to be a really, really good show. Oh, really quick. Auntie Vogliardo. Thank you for becoming, Auntie. Thank you for becoming a member. Also, Lisa, what's up, girl? Lisa Rodriguez said, all right, y'all, I'm here. I've pressed the like button and asked y'all to do the same. Let's go, Tisa. I know that's right. You guys hit that like button if you can. Holly W said, Tisa is preaching. Sing that song of justice. Tweety. Let's sing Diddy's song of justice. Me. That's the way Diddy sounds. Cherry Jubilee said, I can't wait to see the evil pay the piper. CST, oh my goodness. CST and our survivor. That's right, Cherry. I can't wait to see this also. Shout out to you for surviving the unthinkable and still coming out stronger. Thank you for being a member for 5 months, Cherry. We appreciate you. Okay, so let's get into this, right? So we just went through the table of contents. The government is in their bag, all right? Now, let's start off with, okay. The government respectfully submits its opposition to defendant Sean Combs' renewed motion for bail, okay? They said the defendant has previously sought bail on 2 prior occasions, as described in more detail below. The connection with these proceedings, both the government and defendant filed submissions. The government incorporates its prior submissions and okay, that's just paperwork. They said, listen, check at the end of these documents. We got all the mess that made him get denied 2 times. So already the government is low-key trying to set precedent, saying, baby, 3 times is a charm for us. We already got him out 2 times. Come on, be serious. Okay. The defendant's motion should be denied as 2 judges have already concluded, based on the evidence in the record, the defendant poses serious risk of danger and obstructions of these proceedings. And seeking a new hearing, the defendant rehashes the same arguments rejected by these 2 judges with claim of new evidence. They put that in parentheses. But the defendant offers nothing new or material justifying a 3rd bail hearing. In fact, the only truly new relevant evidence shows that Diddy has continued to engage in a relentless course of obstructive conduct designed to subvert the integrity of these proceedings, as described in detail below. While attempting to evade law, law enforcement monitoring, Diddy has, among other things, orchestrated social media campaigns that are, in his own words, aimed at tainting the jury pool, made efforts to publicly leak materials he views as helpful to his case, and contacted witnesses through third parties. Guard, check us out. He got that Tucci. Guard, it sounds like Diddy's on that Tucci again. Tucci, I don't know. For these reasons, the court should deny the defendant a new bail hearing. To the extent the court decides to reopen the bail hearing, however, the defendant's application for bail still must fail under the Bail Reform Act. His motion ignores the significant evidence presented by the government at the prior hearings, showing that the defendant is a violent serial abuser who uses his vast wealth and position in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. In light of this well-documented danger posed by Diddy, the updated proposed conditions of a release are woefully insufficient to assure the safety of the community and the integrity of the proceedings. Now, if you guys don't know, when he wanted to go get released, he he basically wanted to do like not Pablo Escobar, but who's the guy from Colombia? Is that Pablo Escobar? It doesn't matter. He wants to build his own private prison. He said he will go home, pay for 24-hour guards, everything will be monitored, and the government is saying, we have you in our detention center, and you still finding ways to taint the jury and subvert justice. So why on earth would we ever put 6 hours in it? Will we trust you out on your own with a security firm you pay, where everybody's your employee? And when you got your 3 blind mice, the baby oil bandits, your sons rather oafishly doing your bidding. That's Diddy's problem. He kept a lot of people around him that would bend to his will, but then he wanted them to be free thinkers and improvise. But anyway, right? The defendant's request for temporary release pursuant to 3142I should similarly be rejected. The defendant's confinement at the Metropolitan Detention Center, Brooklyn, affords a more than adequate opportunity to prepare for trial, and his convenience does not provide a basis to reevaluate the danger to the community and the threat of the integrity of these proceedings that the defendant's release poses. Again, listen, I know we dragged Mark Agnifilio and all those other people that had to put up with this. At this point, we now see that Diddy is running his own, what do you call it? Diddy's running his own legal defense. And I don't mean to say it like the other lawyers can't do anything. I mean, he's literally running his own legal defense. They can't control him. He's telling him what to do. And he is stupid. He still thinks he's going to bully, connive, and gaslight. Diddy, you are in a jail with glass walls and tapped phones, and everybody is watching what you do, even the people that clean your jail cell. Do they have maids in jail, or do you have to clean your own jail cell? Even the people that clean the jail cells are literally watching what you do, and you still are doing this. At the end of the day, Diddy's in jail not because he's a black man, not because he's in jail because he is an arrogant prick who doesn't know the meaning of integrity, honestly, but most important, he doesn't know the meaning of the word shame. He just doesn't. He is shameless. Anyway, right? Kiki Culture said, you have to watch the last night's video featuring Keisha Cole because it says a lot. I would love to see you break down things like that as a public opinion evidence. Love you down. Love you. Love and prosperity. Thank you, Kiki Culture. And you know what? I'm going to make a note of that. Break down all the Diddy's videos. I like that. Thank y'all. I really appreciate that. Let's see. Break down all of Diddy's videos. Break down Diddy's videos. Shut up. I'm not much of a typer. Okay. Let's get back into this. All right. So, more Diddy news is coming in. Oh my God. Oh my God. You know who I feel sorry for? Quincy. Because his real daddy is a God. Like you're oof, God. Anyway, let's get into this, right? I'll make a video about that. I feel sorry for Quincy because I'll be sure y'all keep trying to make that man into a hero. I don't care. He once a deadbeat, always a deadbeat, and he keeps showing his ASS and showing who he is. But we'll talk about that in a different video, right? The indictment and the defendant's arrest. We can skip over that because y'all know this. Y'all know that too. Okay. Okay. Oh, this is good. Let's get to the applicable law because I think a lot of people skip over that, but this actually tells you why it's kind of not going to work. Okay. Let's just get into the applicable law. Y'all know the background, or else y'all wouldn't be here. Okay. Applicable law. Under the Bail Reform Act, the district court has discretion to reopen a bail hearing if information comes to light that is both new and material to the detention in question. Specifically, a bail determination may be reopened, this is what Diddy's trying to do, before trial if the judicial officer finds that information exists that was not known to the movement at the time of the hearing and that has a material bearing on the issue whether there are conditions of release that will reasonably assure the appearance of such person as required. So what does that say? You can reopen a bail hearing if there was information that is completely new. New means that it was unknown by you. However, unknown could be actually unknown, but it cannot, so unknown means that it needs to be actually unknown, meaning it cannot be a remix of different evidence. You can't say, oh, well, I didn't think of that then. That's not unknown. You knew this person exists. You knew the charges. Anything else, that's your own fault if you didn't bring it up at the first time. On top of that, they say that also, if the condition of release is if they can show new information, that there's some type of guarantee that you're not going to be a danger to other people. Because that's the only reason why you get taken off the street and put in jail. They prove that you are an actual danger. Okay. They said courts in the second court, that's the appeal court, have found that that new and material information, right? For section 3142, that's the section that says, you have to be able to put on, be able to mount an adequate defense and be in a situation that lets you actually mount an adequate defense by researching, being with your lawyers, this and that. The Second Circuit has found that new and material information consists of something other than the defendant's own evaluation of his character or the strength of the case against them. Truly changed circumstances, something unexpected or significant event. Moreover, the Bail Reform Act states that only a hearing may be reopened if new and material information is presented. It leaves the decision to reopen the hearing to the sound discretion of the district court. Therefore, even if the defendant's arguments for reopening the hearing meet the standard, which they do not, this court may still decide in its discretion to not reopen the hearing. Section 3142 provides that a court may permit the temporary release of a person in the custody of the United States Marshal or other appropriate person to the extent that the judicial officer determines such release to be necessary for preparation for the person's defense or another compelling reason. However, this provision has been used sparingly to permit a defendant's release where, for example, he is suffering from a terminal illness or serious injury. So Diddy's lawyers are basically saying, yeah, you guys are citing the law, but the law must be applicable. I know the law says A, but we need to look about the history of how the courts have applied it. The courts have only applied it when somebody is terminally ill or seriously hurt, injured, or whatever, okay? In considering whether a release is necessary for preparation in a person's defense, the Bail Reform Act simply requires that the defendant in custody be afforded a reasonable opportunity for private consultation with counsel. Reasonable doesn't need to be perfect. It just needs to be reasonable. Reasonable, what is or is not reasonable, the courts usually side with the government because the government, for good or bad, is looked at as the righteous people, the people on the right side. Okay. They said here's the shade they threw at Diddy. They said, by the way, pretrial detention will always interfere with preparation for trial to some extent, but the Bail Reform Act clearly contemplates this problem and allows for detention provided that the defendant is afforded reasonable opportunity for private consultation. The defendant has the burden of showing that temporary release is necessary for the preparation of the person's defense. Why do I feel like Diddy was in jail on some Malcolm X, assalamu alaikum, brother? And he read this and he thought he was about to get, he was in his bag writing, waking up his lawyers at 2 a.m. in the morning, only for them to be like, that it's not the way it works, Mr. Combs. That doesn't really count. Okay, let's get into the discussion, right? The court should reject the defendant's attempt to reopen the bail hearing based on the same information he presented Judge Carter. Diddy's motion to reopen the bail hearing should be denied for the simple reason. And you guys, this is going to get really, really good. I like to start slow because when we get into the nuts and bolts of this, I'm telling you, your jaw is going to drop open, okay? But you gotta know the basis, the framework, the groundwork for what the government is cooking up for you to understand how shocking what Diddy did is. Okay. Diddy's motion to reopen the bail hearing should be denied for the simple reason that he has not presented any information that was not known to him at the time of the bail hearing before Judge Carter. Judge Carter is the judge that just resigned. Well, he recused himself because his calendar was too full, okay? As set forth below, the defendant Diddy asserts that the court should consider new information relating to Diddy's relationship with Cassie. That's victim one, I assume, and his communications with various witnesses as a basis to reopen the bail hearing. But these allegedly new facts are the very same arguments made by the defense counsel and rejected by the district court previously. It's just dressed up with recently produced discovery because those facts were well known to the defendant before any discovery production. And because the defendant relied upon them in his prior hearing, he can't recycle them here to revisit the sound determination made by Judge Carter. And the defendant is a danger and a risk to obstruction and must be detained. So that's already a first blow. Whenever I read that, I said, Diddy ain't getting out of jail. For anybody joining us, the federal government said, first of all, he ain't gonna have another bail hearing. Your Honor, rejected. But even if you want to hear this bail hearing, there's no new information. He had the same information before he asked for discovery. He now thinks he has a new and novel argument, but you only get one bite at the apple. At this point, Diddy got two. It's not new information. So why are we allowing this remix? This is not a Bad Boy reunion tour, and you're not doing a remix. Diddy's rehashing of the same personal attacks he made against Cassie before Judge Carter is not new information. Diddy claims that communication between himself and Cassie, which were recently produced in discovery as part of Diddy's electronic devices and accounts, constitute new material. But Diddy's claims that the recently produced text messages reveal a loving, at times toxic, long-term relationship between two adults who decided to mutually break up. Pause. Hit my Dame Dash button. Pause, right? Because this is actually like really scary. Because Diddy doesn't realize in saying this, you are pretty much a group. You don't realize that in saying this, you are pretty much agreeing to the fact that you feel no remorse to what happened with Cassie. You feel no remorse in how you treated anyone. If anything, you look at it as a loving, at times toxic, long-term relationship between two adults who decided to mutually break up. So this is the way he felt about what he did to Kim, probably what he did to Misa, what he did to Cassie, what he did to Gina Han, probably what he's doing to Janet Tran. I don't know. I think people don't change. I don't know what's going on in the relationship, but Diddy doesn't seem like a changed man. And what he does to everyone. The fact that he actually put that in his request for bail, letting us know that this is what relationships look like to you. Why would we let you out on the street? you're going to get another girlfriend and do the same thing to her because that's what love looks like to you. At times toxic. This claim is nothing new. The defense counsel made these exact points previously and even referred to text messaging and communications. At the September 17, 2024 hearing, after noting that he had looked through more text messages and emails than he cared to, that was Mark Agnophilia trying to get smart with the U.S. Attorney's Office. I remember that in the bail hearing, they didn't take kindly, and now it's their turn to clown Mark again. Listen to what they quoted Mark saying. This is the defense counsel observed. This is a 10-year relationship. This sex trafficking is a 10-year relationship. These two people were in love. That will be made abundantly clear by the way they speak to each other, by the way other witnesses describe their time together, and by the circumstances of how they broke up. They were in love, but Diddy wasn't always faithful. At the end of the day, there was mutual philandering, and Cassie ended up marrying the trainer that Diddy got for her and had 2 children. That signaled the end of the relationship. Mark Agnophilia really stood in front of a federal court judge and saying that Cassie getting married and having 2 kids signals the end of the relationship. I guess I could earn $180,000 a week. The government, so they're clowning Mark Agnophilia because they pointed out the stupidest part of his argument. So then they said, there is nothing about the content of the text messages between the defendant and Cassie that was not known by Diddy at the time of the initial hearing. Furthermore, in presenting recently produced text messages, Diddy is cherry picking in order to paint a misleading picture, ignoring numerous other messages in the record between Diddy and Cassie, documenting the defendant's physical abuse of Cassie and his threats to expose recordings of the free calls. Again, if these free calls were consensual, why was Diddy using this to blackmail her? And we got it on text messages blackmailing. Again, Diddy is a liar. Like, it's giving like American Psycho. Anyway, right? The text message read, "You know what sick and disgusting ish I was reminded of the other day?" I'm sorry, this is Cassie. "You know what sick and disgusting ish I was reminded of the other day? You forcing me to blank, or you were going to leak some freak off shit. I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. I turn my head for a second and you get effed up and you drag me down the hall by my hair. I have bleeding cuts. You hit me in the head 2 good times. When you get effed up the wrong way, you always want to show me that you have the power and you knock me around. I'm not a rag doll. I'm someone's child." Moreover, despite attaching lengthy text messages between Diddy and Cassie on various dates between August and November 2018, Diddy omits messages preceded in the same thread of showing his violence. And then they give the thing showing his violence. Diddy also rehashes his attacks on Cassie's motives in bringing a civil lawsuit against Diddy, suggesting that Cassie's allegations against Diddy were merely attempts to obtain a financial windfall from Diddy. Across multiple bail hearings and in the instant brief, Diddy has made clear that his litigation strategy is to personally attack Cassie, stooping to any death to attempt to undermine her credibility. Setting aside this questionable strategy, none of the information that purportedly undermines Cassie's motives was unknown to Diddy at the initial bail hearing. Again, defense counsel made all these arguments previously, and the arguments have no bearing on the question of bail. The purpose of the bail motion, Your Honor, is to determine whether there are conditions that will assure the safety of the community and Diddy's appearance in court, not to entertain the personal attacks on a statutory victim. To the extent the defendant takes issue with Cassie's credibility, a trial is the appropriate forum to address that. Ow, they got him, right? But again, I have long said this. People that defend Diddy don't understand what a statutory victim is. A statutory victim is whether you think you did them wrong and whether they think they did them wrong. It doesn't matter. You shouldn't have done it. Just like if you are talking to a 15-year-old, It don't matter whether they wanted it. It don't matter what. It don't matter. At 15, it's illegal. Point blank. That's it. Just like offering Kalina money to change her testimony or change her statements. It don't matter that Kalina did it willingly. It don't matter that y'all had an agreement. What you did was illegal, because when you go in front of a judge, you must tell the truth and the whole truth. You can't change it according to who's paying you just because y'all smack hands, get your rent paid. And I don't know, did he give Kalina, hold on y'all, did he give Kalina the rest of his Tucci staff? Because I saw her in that interview. She was zooming and sleepy all at the same time. Anyway, let's get into this, right? Okay. B, the court should reject Diddy's request to reopen the bail hearing because defendant disagrees with the government's use of the term victim. Now, this was King. Who the F do you think you are? That you are literally telling the government what words mean. I'll tell you one thing too. Diddy really pissed off the government. Diddy next accuses the government of misleading the court as the nature of certain as the nature of some of the defendant's communications with another victim. The government did no such thing. The defendant's primary point of contention appears to be the government's characterization of this individual as a victim, and quibbling about how to label victim two an individual. Now, here's the thing. Who's victim two? Listen to who victim two is, right? An individual with whom Diddy continues to pay a significant monthly sum. Let's look at the footnote. Bank records show, they have a footnote on this. They said bank records show that the defendant's payments to victim number two as recently as mid-September 2024, the government has requested and is awaiting updated financial documents through to the president. Oh, Diddy, you going down. The defendant, Diddy, does not present any new information or grapple with the actual evidence. The messages and recordings between Diddy and victim two, on which the government relied at the initial bail hearing, are clear on their face and consistent with the government's representations. The defendant was leveraging significant financial benefits to cause victim two to adopt his narrative of their relationship. Now, whether or not Diddy agrees with the characterization of victim two as a victim for purposes of this criminal case, the communications highlighted by the government indicate that Diddy used financial coercion as an attempt to feed victim two the narrative that was consistent with his defense theory, a theory at odds with text messages that were sent at the same time by victim two to the defendant and others. The defendant, that's what they said. Diddy just threatened me about my sex tapes, where I'm heavily drugged and doing things he asked of me. That's when she was describing her sexual trauma. In light of defendants' continuing financial support of victim two, it is not the government, but rather the defendant that's misleading the court. Now, let me just say this. This was some bold mess. Why? Because there are text messages of her saying that Diddy tried to this is not Cassie, this is a different woman, that Diddy tried to blackmail her with her own blank tapes where she was drugged. And because of that, she started taking Diddy's payout. And Diddy knows this, and he still stood in front of the court with his judge and lied about how come I'm not out on jail with the rest of the sex traffickers. Now, here's the question I want to know. Who's victim number two? Now, I know what y'all thinking, because I thought this. Is it Gina Hun? But here's the thing, and I think I talked about this in a different video. We didn't know Gina Hun existed until she popped up on Tasha K. And I'm not saying Gina Hun is nobody. That's not it. It's just the point that Diddy always kept his dating profile low key. It wasn't until she came out and said, hey, I'm one of the girls dating Diddy, that she get on our radar. How many other Gina Huns are there? How many others? How many other women? We didn't know about Dana Tran until Dana popped up with Baby Love. How many other women are getting the Gina Hun special, the Kim Porter special, right? How many other women are getting the Dana Tran special? I'm just saying. It also seems odd to me that Diddy had Baby Love, and I think she was born like around Thanksgiving, right? Because if you think about it, Cassie filed suit at like the beginning of 2023. It's almost like Diddy immediately ran and got Dana Tran pregnant, and they rebranded him as a loving father, love, 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 and that was his rebrand. Do you think Dana Tran feels some type of way? Because think about it. Last year, you had the youngest child to a billionaire that looked like he was a loving dad and loved to spoil his kids. And now you got a 1-year-old. How old is baby love? You got a 1-year-old with a social pariah whose money is fast diminishing. Dana Tran better get on monster.com. She better get on monster.com because I don't know like how far Diddy's money is going to go. And even if it can't support her, you're going to be living a very comfortable middle class lifestyle. I think those yachts off of Saint Tropez are going to dry up unless you find another sponsor. I'm just saying. Kiki Culture said, oh yeah, we already read that. Thank you, Kiki. I am going to look into the last night video. Also, It's Above Me Now said, thank goodness I caught the 5 o'clock news. Hey, Tease, I've been waiting to catch a live. Oh, thank you. It's Above Now. It's Above Me Now. Maja Keys, what's up? Said, I can't listen to any of Diddy's songs or songs he produced without looking sideways. Just sad and disgusting. It's been in our face for all. Remember, what is it? Dirty Money, Last Train to Paris. And he said that what he was making, in an interview, he said, he's like, I'm bringing forth a new sound. I like to call it train music. He said that. And the thing, we were like, oh, okay, I guess train music. I mean, it seems weird. I don't know why Amtrak would be playing that, but sure. Now we know that he was really talking about a choo-choo. Anyway, right? Magic Keys also said, girl, I hear you. I wonder if Diddy's oldest daughter, Chance, wants to separate herself from it all while in college. I'm sure this has to be horrendous for her. I'm sure it is too, but you see the way that Chance even had to call in from college? You know that Diddy set up that whole birthday call. That was his idea. He told them exactly what to do, and then he had them give them the analytics to see how everything was. Diddy thinks he's going to worm his way out of this, but he got another thing coming. Let's go to part C. Defendant's contacts with the witnesses demonstrate the threat he poses to the integrity of these proceedings. The defendant's attempts to spin his contacts with witnesses, including witnesses served with grand jury subpoenas, as evidence rebutting the government's proof of obstruction fell in their entirety. That was a read. For example, Diddy claims that the government misled the court and concealed the actual content of the communications between Diddy and the witness who was served with a grand jury subpoena in June 2024. That's witness one. As an initial matter, the nature and substance of Diddy's communication with witness one was known to Diddy at the time of the initial hearing. But more importantly, the contacts, including the fact that Diddy evidentially deleted the messages from his phone, confirmed the government's proffer at the initial hearing and refutes statements made by defense counsel. Diddy sound like Tristan Thompson and like every cheating man. You really think deleting something from your phone makes it go away? The government was probably sitting there bored, like, yeah, how much are we gonna have more freak off talk? And then they saw him delete the things and they said, we got him. Guess what? Gotcha. Oh my God. There's a mosquito flying around. Sorry, I'll focus. There is a mosquito flying around. Okay, so anyway. Okay, fine. Okay. Phone records show. But more importantly, phone records show that between the end of 2022 and 2024, witness one occasionally contacted Diddy by phone without any response from Diddy. Yo, what is this? Doesn't this sound like Roger Bonds? Okay. That changed in June 2024. Witness one was served with a grand jury subpoena on June 19, 2024, and after contacting the government, was appointed counsel on June 25th, 2024. So the government gave them their own attorney. Beginning on June 26, 2024, only after witness one had been served with a grand jury subpoena and have counsel, the defendant, Diddy initiated contact with witness one, which Diddy attempted to obscure by initially calling, oh my God, witness one's wife. Is Roger Bond married? Maybe not. And later communicating with witness one over a VoIP service. I assume that's like one of those services like Signal that you can't like trace, including by text and a call lasting over 7 minutes. The following day, phone records indicate that witness one spoke with counsel for the defendant, for Diddy. Even though witness one was represented by counsel, he and Diddy continued to directly exchange text messages, and Diddy's lawyers also spoke directly with witness one again on July 8, 2024. Following witness one's testimony in the grand jury on July 25, 2024, the defendant called and texted witness one again. Now, why is that so big, right? Because I know what it is thinking, oh my God, so what? He talked to Diddy directly. Why is that illegal? Well, there's a couple of reasons about why that is a bad idea. For one, if you are a lawyer, right? If somebody, if you are a lawyer, right? If somebody has counsel, legally, because you're a lawyer, you are not allowed to speak with laymen once they have counsel. That's what they call people that don't know the law. You're a layman, right? Because you could trick them. They could go so far. You must try to get in contact with the counsel before, or whatever. So it looks, and let's not forget that they say that after that he was appointed counsel. That means the government gave him a lawyer. Okay, so you went around the government's lawyer and you talked to somebody without involving their counsel, which for Diddy is really weird. But here's even more weird. Diddy's lawyers know better. You know you should not be speaking to someone that has representation without involving their counsel, which makes me think, remember Mark Agnifilo was on the steps after the bail hearings about, I don't know, we're trying to find out. Yo, what if Diddy's lawyers were also helping him obstruct justice? I'm just saying. Seems like they were involved. So that's why this is so big with the government. You shouldn't be talking directly to this thing. You should be going through his counsel. It is highly unusual, and it looks like you guys are trying to do something shady. And if you don't know this, Diddy, your lawyers know this. Diddy's repeated contact with witness one, despite his apparent knowledge that witness one was represented by counsel and had received a grand jury subpoena, undermines Diddy's lawyers' previous denials of Diddy's interference in the government's grand jury investigation, and shows that Diddy's lawyers cannot stop Diddy from contacting grand jury witnesses. Now, why is that so important? Because Diddy's saying, I swear, Your Honor, if you just let me out, I swear I'll be a good boy and I won't do anything and I don't even. They're saying his own lawyers can't control him. So if his lawyers can't control him, and he's violent, and it's a RICO, and this and that, and he doesn't even see what he did as a big deal, why are we letting this mofo all out in the street? Good question. They said the concern is amplified by evidence indicating that Diddy appears to have deleted his messages with witness one. Although the phone records confirm that Diddy, using a particular phone number, and witness one exchanged multiple text messages from June 2024 through August 2024. There was no such messages recovered from Diddy's cell phone associated with the phone number. On top of that, like they said, this person tried to reach out to you multiple times before the grand jury stuff. You never returned the calls. As soon as they got served that subpoena, that's when y'all was like, he my best friend. He a real bad. That's when y'all was in the best friend, right? Again, they said for proof, see September 18, 2024 on page 42 or on paragraph 42. He did not reach out to any grand witnesses. They're clowning Mark Agnifilo again because Mark Agnifilo really tried to destroy them in court at the last bail hearing. I told y'all they wasn't going to like that. So they're quoting Mark. Yana, he did not reach out to any grand jury witnesses. That's a lie. They said we have proof. He was talking a whole bunch to witness one. I dispute that wholeheartedly. He didn't do it, and he wouldn't do it, and he wouldn't do it because he has the sense not to do it. and he wouldn't do it because we wouldn't let him do it, you know? Yo, they just perjured Mark Agnifilio. For y'all that are not listening, the federal government has just not even accused, offered proof that Diddy's lawyers lied to a United States Southern District of New York federal judge. When not only did they know Diddy was contacting Witness One, but they themselves also contacted. Yo, okay, I know this is like legal nerd stuff, but we have studiously avoided interviewing grand jury witnesses. That's a lie right there. They said that they actually quoted CNN.com. They said it's a video. Mark Agnifilio, Diddy, Sean Combs, SRC, DIG, counsel for defendant discussing speaking with witnesses in the case and stating, we cannot try to interview a grand jury witness. Good job, government. Yo. And they tried. Okay, so now they go on to witness 2. You guys, we're going back into witness 2. This is the court should reject the defendant's request to reopen the bail hearing because the defendant disagrees with the government's use of the term victim. We already did that. The defendant's contacts with witnesses demonstrate the threat he poses to the integrity of these proceedings. We just talked about witness 1. Let's get into witness 2. The defendant also claims that Diddy's contacts in September 2024 with an individual represented by counsel who wanted to make a public statement. That's witness 2. We can call her Kalina, the first of her kind. Were not in any way obstructive because Diddy and Kalina were previously in frequent contact. However, the contact between Diddy and Kalina, who were bandmates, that stopped in March 2024. And from the timeline and the context of Diddy's contacts with Kalina, it is clear when when Diddy reinitiated contacts with Kalina in September 2024, his purpose was to ensure that Kalina was on his side and to pressure Kalina to make a public statement denying allegations of violence by Diddy. Diddy reached out to Kalina on September 11th, oof, that's heavy, and sent her a copy of the lawsuit against Diddy in which Kalina's name was mentioned several times. Diddy then called Kalina and they spoke for nearly 6 minutes. After reading the lawsuit, Kalina called Diddy back at his request and they spoke for over 4 minutes. Evidently, Diddy and Kalina discussed Kalina drafting a statement as immediately after the call. Diddy told Kalina in a text message, blank, blah, 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 blah. The defendant then asked Kalina for her attorney's name. Now, here's the funny thing, right? The reason why they can only say that they only talked for 6 minutes, 4 minutes, all this stuff is because Diddy was probably clearly calling them from Signal or a place that is impossible for them to go into this. But that said, the government, I think, has been tapping Diddy's phone. So maybe he calls her from a burner's phone and all they can see is that they call Kalina's because they subpoena cell phone records on Kalina's side. From September 11th, 2024 to September 15th, the defendant and Kalina exchanged multiple text messages and multiple calls, at least 128 phone contacts in total. Throughout these phone contacts, Diddy repeatedly asked Kalina when she planned to post her statement. Kalina ultimately made a statement about the lawsuit via an Instagram post on September 13th. Then after the defendant was in custody, the Bureau of Protection investigators recovered the following notes from Diddy's cell during, oh my God, y'all. Hold on, let me get on a big screen. Y'all, remember that raid that happened at Diddy's prison? That Diddy's attorneys were like, see, this is proof that the prison's unsafe. Let my people free. Y'all, the purpose of that raid was to get into Diddy's cell and see what he'd been writing. Because look what they put. While Diddy was in custody, the Bureau of Investigators recovered the following notes from Diddy's cell during a pre-planned nationwide sweep of the Bureau of Prisons facilities. Woo, they said, with respect to the materials received from the Bureau of Prisons that included possibly privileged materials, such as notes recovered from Diddy's cell, the prosecution team only assessed those materials after they had been reviewed by the filter team. Discussing the potential options, including the government filter team for review of potential privilege. So, they're going to use this in court. So if you guys don't know what the filter team is, if you come, so attorney-client privilege is protected. That is any communications, also any work product, any notes that were made while you were meeting with your attorney, or in preparation to meet with your attorney, or in preparation to trial, is considered attorney-client privilege, but is protected because it's called work product, I believe. The work product is anything that was made to help. So when they found those notes by the Bureau of Prison, to make sure that they could use that in a trial, they gave it to the filter team. The filter team is supposed to be a completely autonomous team that has no agenda, wink, wink, has no agenda, and they view it to say, hey, this violates attorney-client privilege. You cannot see this or read it, or yeah, you're cool. You get the green light. Go ahead and use it. They had the filter team look at it, and the filter team said, guess what? This ain't attorney-client privilege. You can go use this, have fun, and God bless. And because it went to the filter team, Diddy's team can't get it thrown out of court. Oof, they mean business, and we love to see it. Really cute. Quick, Brown Sugar said, hey, Tattletale, don't let the mosquito bite you. Also, Covert Super Pro said, Willow Smith cut her hair. Get out. Okay. I don't understand that with Willow Smith. Let's not talk about Willow. We love Willow. Meet me at the park. Willow is such a pure soul with such a beautiful voice. Okay. They said the strong inference is to be drawn from Diddy's communications with Kalina and his personal notes is that Diddy paid Kalina after she posted the statement. Is Diddy on that Tucci? I would be surprised. Well, I know the feds could never do that because that was illegal. But do you think that the feds are actually giving Diddy Tucci so he can do this? You are literally trying to run a criminal organization through a tapped federal line, and you didn't think the feds were going to bring that up? You literally kept notes of all the people you were harassing, intimidating, coercing, and paying off. You had your little checkbook, your little Chase account, debits and credits, debit. Literally, when you're writing checks out to these people in the memo for keeping thy mouth shut, for ignoring me drop kicking a woman in the face, in the memo line, like how dumb do you gotta be? Anyway, I don't think it's dumbness. I think it's arrogance, actually. Let's get into this. From the timeline, the content and the context of the communications between defendant and Kalina, Diddy's clear goal was for Kalina to draft and post a statement. Even after Diddy knew that Kalina had a lawyer, he continued to reach out to her directly, a fact that clearly concerned Judge Carter, and rightfully so. That Diddy had multiple phone contacts with Kalina up to and including March 2024 changes nothing about the damning timeline and the content of the calls in September 2024. Okay, so they do have the calls tapped. These communications are another example of Diddy using manipulation, influence, and power to persuade witnesses to support him. Based on the foregoing, Diddy has now demonstrated that he is entitled to reopen the bail hearing. And the law cited by Diddy provides him no support otherwise. Diddy's reliance on United States v. English is misleading. The citation by Diddy suggests that when cases are reassigned to new judges, the court should review the record de novo when considering bail motions. The Second Circuit's holding was not that broad. In English, the Second Circuit held that the district judge, before whom a bail motion is properly made, should consider the subsequent factors and make determination required. I see what they're saying. So they're saying that even Diddy's request for this second bail motion is legally flawed because in English, what is it? United States v. English? Yeah, US v. English. In the English case, they had a right to go up in front of the judge for bail. They had a reason to be there. So based off of that, they said, okay, let's hear it. However, the U.S. attorney is offering, saying now with Diddy, you don't even qualify. It's like saying that if it's like saying if you are over 5 feet, you can ride all the rides at Six Flags, right? And then saying, well, since I can ride a ride at Six Flags, I want to ride the Twister. But they're saying, no. You're arguing about whether you can get in the Twister line or not. You shouldn't even be in Six Flags. You are 4'5". Get out of here. That's what they're saying. You don't even qualify to even ask for this. Blah, 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 blah. Thus, the inquiry is 2 steps. First, the court must determine whether the bail motion is properly before it, saying, do you have a right to even request one? 2, only if the court finds in the affirmative should the court consider those factors. Here, because Diddy is not satisfied the first prong, the court doesn't even need to consider the factors. The case is cited by Diddy to support his contention that this court has inherent authority to reopen a bail hearing is equally misleading. Those cases involve a district court reconsidering its own bail decisions. The second court has explicitly held that, as is the case here, when 2 judges of the courts have original jurisdiction over defendants' offenses, neither is authorized to review the detention by the other. Now, listen, let me just also say this. And I've said it a million times. People need to learn the definition of statutory. Statutory means whether it was consensual or not, whether you meant to or not. If you do the things that are listed in the statutory law, then you have done those things. It doesn't matter whether you meant to, did this, did that. If the definition of taking somebody's life is at your own hands, somebody stops breathing, it doesn't matter whether you meant to murder them, whether it was an accident, whether you planned it out. You statutorily took somebody's life, and there might be consequences behind that. Why do I say this? Kalina, right? Kalina is trying to convince us that because she was down to change her testimony and Diddy was down to pay, then let me do a Kalina. Can there be no witness tampering? Because Dawn, the weird effort. That is weird. She weird. I'm sorry, if y'all haven't seen Kalina's interview, she's funny. Head knocking back, slurring, falling asleep, doing all this stuff. And yes. But on top of that, the only time she actually got active was to talk about Dawn and how weird she is and how she's going to expose Dawn for being a freak with a lot of guys, even though you defending King Freak Sean Diddy. But you know what? Let's keep going. Let's keep going, shall we? That was my imitation of Kalina during her thing. And I think that Diddy set up that also with her too. But let's keep going. Okay. Let's get into the next thing. Shall we? Put this on Summer Dram screen. Okay, so Diddy cannot rely, Section 2, Diddy cannot rely on Section 3142 for his release. Alternatively, Diddy moves for pre-trial release under 3142, claiming that Diddy cannot adequately prepare for his defense at the MDC. That law does not support Diddy's release from under this provision either, as Diddy has amply been afforded reasonable opportunity for private consultation with counsel at the MDC. First, the MDC has provided that Diddy, with more than reasonable accommodations, met with counsel. Diddy is permitted to meet with counsel 7 days a week and regularly has access to a separate conference room off the common area of his unit. In fact, records indicate that Diddy has met with his counsel most days since he's been in custody. Records also indicate that the defendant frequently communicates with his attorneys by telephone and written communication, including, as explained below, through unauthorized means. But even if Diddy were only being authorized channels, only use authorized channels of communication, the MDCs, that's the detention centers, procedures do not infringe on Diddy's constitutional right to effective counsel or to participate in his defense. They cite UV versus El Haag, holding pretrial detention conditions, which included solitary confinement, restricted phone access, and a chair to review discovery more comfortably, were reasonably related to defendants' specific security concerns and did not impermissibly infringe on defendant's ability to prepare for his own defense. That's UV Muhammad. Damn, you know what? Hold on, guys. You know why this is crazy? They are bringing up laws that were actually enacted while, after 9/11, when they were like clamping down on anybody that had a Muslim surname. So that's really weird that they're actually bringing that up. Let's keep going. Where are we at? Second, Diddy's defense counsel proposal that Diddy must be released in order to prepare his defense. Hold on, y'all. I gotta open the window. It's so hot in here. Hold on. But I'll keep reading. Second, defense counsel's proposal that the defendant must be released in order to prepare his defense is inconsistent with the Bail Reform Act, which contemplates that courts will weigh dangerousness and risk of flight against a defendant's opportunity to prepare for trial. Okay. Where are they going with this? In this case, the significant danger that Diddy poses, okay, weighed against the opportunities the MDC has provided the defendant to meet privately with his attorneys, clearly counsels in favor of the defendant's continued detention, saying pretrial detention will always interfere with preparation for trial to some extent. But the Bail Reform Act clearly complicates this problem and allows for detention provided that the defendant is afforded reasonable opportunity for private consultation with counsel. Now, this is the best part. They said, thirdly, voluminous discovery alone is not a basis for release under the Bail Reform Act or even the Sixth Amendment. Now, in Tattletales, we've been saying this a while. Diddy somehow thinks that because this is so stupid. It's like it's law for one. They think because they asked for all the discovery, and then the discovery is so much because everybody knows that the federal government buries you in evidence. Diddy somehow believes that that is the reason for him to get out, and it's a violation of the Sixth Amendment. Diddy does not, and here's the thing, again, this shows that Diddy is the one running his own legal thing, because you can't tell me that Diddy's lawyers or Mark Agnifilo or anybody for that matter actually took this seriously. This is the way somebody that is a first-year law student would read the law without even applying. And it's like a habeas corpus. Like, wait, hold on. They said that I need to prepare for trial. And you're like, yeah, but that's it's like a first-year law student. So I think that he's on his the autobiography of Malcolm X. Literally, probably like it'll tell like bean pie, my brother. No, shade the bean pies. You know we love them. But honestly, I think Diddy is running his own thing, and they can't control him. Anyway, let's get back into that. They said Diddy does not point to any case law suggesting the discovery of the kind produced in this case requires Diddy's release under 3142. Now, they actually quote a case Dupree. While this fraud case may, in fact, be complicated and require the defendant, this is in Dupree, to review hundreds, if not thousands of documents and meet with his lawyers for dozens of hours, that fact, standing alone, simply does not justify defendant's release. Indeed, accepting such an argument would mean that more complicated crime, the more complicated a crime, the more likely a defendant should be released prior to trial. This is clearly an absurd result. Yo, by them citing Dupree, you guys don't realize it. They are clowning the dog mess out of Diddy. And more importantly, they're clowning the dog mess out of Mark Agnifilio and whoever else wrote this, saying this is such stupid legal reasoning. But listen to this. And I think this is the most important thing which they're trying to get at. And I think they're being very subtle about it. But yet and still, I see them for their works. Diddy's new judge is a very young judge. He's only 40 years old. That's very young, especially when it comes to federal judges. He hasn't tried that many cases, right? But yet and still, he is very adept and he knows a lot of case law, hence why he got an appointment so young. Diddy's lawyers are literally hoping that the new judge, the young one, is a dum-dum. And when you think a judge is stupid and doesn't know the law, you take law and you misread it on purpose. And then you write up your brief saying, this case says A and this case says B. And you submit it to the judge and you basically hope that you can gaslight the judge. You hope that you can gaslight the judge into believing that this case law is applicable. What the federal government is doing by breaking down Diddy's stuff, saying Diddy, ain't nobody stupid, but they're also telling the judge that Diddy thinks you're stupid and his defense counsel thinks you're stupid to even try to pull up this thing. You know what I'm saying? They even try and do it. They think that you're stupid. And that's a really good way to offend the dignity of a federal judge. And once you've offended the dignity of the federal judge, after that, when you're in trial and you're like, objection, Your Honor, and the judge is like, on what grounds? Sit down, counselor. The judge, by the time the courts have started, one, the judge doesn't trust you because he knows that you will try to gaslight him. Now, every lawyer, you take liberty, but flat out gaslighting or even purposely misleading a judge because you think you're going to get away with it, that's a way for you get the court. The judge doesn't trust you. So everything you're saying, they're reading through because they know you're trying to pull something on them. Two, you've affronted the judge's dignity. You really think this guy's an idiot and you tried it, but you're going to pay for that. Just wait till they start throwing those objections, Your Honor. Objection, Your Honor. On what grounds? Counselor, sit down. Sit down. Sit down before I make you sit down. That's going to be Diddy's experience in court. Anyway, right? Okay, where are we at? Okay. Okay, here we go. The Bail Reform Act does not mandate the defendant's release, even if review of discovery would be more convenient outside of the detention facility. They have cited another case, holding that even where release would certainly make it more convenient for him and his counsel to prepare for his defense, release was not necessary given substantial accommodations for discovery review. Moreover, Your Honor, the aggressive trial schedule was specifically requested by Diddy. If he needs more time to review discovery, he can request the adjournment of the trial date. Finally, Diddy's complaints about conditions at the MDC comes as a surprise to the government, given the contrary public statements made by defense counsel. I told you they wasn't going to let Mark Agnifilio go. And statements made by the defendant's monitored calls. Oh, hold on, there's a footnote. Let's get into this. The monitored calls, C. Quinn Liam et al., Sean Diddy Combs' attorney, says, food's probably the roughest part of this, of the mogul's life in prison. They cited People, October 10th, 2024, and then gave a link to the article. Then they said, Diddy's complaint that he still does not have a laptop is overstated. At defense counsel's request, the government prioritized production of Diddy's electronics devices, which Diddy is not entitled to keep at the MDC due to the designation as attorney possession only. The bulk of the materials that Diddy is entitled to keep at MDC were only produced recently, and immediately following the production of those materials, the government began preloading Diddy's laptop and expects to provide the laptop to defense counsel in short order. So they also said they're using Diddy's request for a laptop against him. He wanted his laptop. He thought he'd get it to get him back before they stripped everything from it. They're saying, oh, no. We're almost done mining your laptop. And when we're done, we'll give it back to you. And then you can have it in MDC. Anyway, they said, finally, Diddy's complaints about conditions at the MDC come as a surprise to the government. We talked about that because Mark Agnifilo said the hardest part is the food. Given the contrary public statements made by defense counsel and statements made by Diddy's monitor calls. Additionally, Diddy's lawyers have made no attempt to cooperate with the government about their concerns. Nonetheless, the government stands ready to engage with Diddy's lawyers on the issue if needed. Now, let's not forget that Diddy's lawyers tried to put the U.S. Attorney's Office on trial and say that they were doing this, doing that, said they had leaked information, said they were leaking to the press. They literally tried to embarrass the U.S. Attorney's Office. So now this is actually coming back to bite them in the butt. Okay, let's get back into this. Okay, so that was a fail. 3, Diddy possesses a serious risk of obstruction, danger, and flight. For the reasons discussed above, Diddy has not met his burden of demonstrating that he's entitled to a hearing under 18 U.S.C. 3142. Accordingly, the court need not make a determination regarding Diddy's flight or dangerousness. However, even if the court were to analyze the factors, again, the court should continue the defendant's pretrial detention because no condition or combination of conditions can assure that Diddy's appearance and the safety of the community, nor can any conditions prevent Diddy's continued obstructive efforts. The incorporated submissions and arguments presented to Judge Tarnowski and Judge Carter amply support those findings. They put that in Exhibits A and B, and as described further below, the argument for detention has only gotten stronger. Now, I have to pause this and ask. In class, if you know the answer, let me know. Why couldn't Diddy just chill? I'm not saying he has to chill all the time, but in this case, you knew that your trial was coming up in a few weeks for a new bail hearing. Why didn't you just chill? Stop witness tampering, stop calling people, stop buying minutes, stop bribing people in commentaries. Why didn't you just chill? And again, the answer is overall, because he can't, because he's incapable of chilling. Because this is who he is to his core. He is a menace to society. He is. He is a menace to society. Also, it's just a menace. Brown sugar. Again, I keep looking at your mosquito bite comment. Let's get into the last one. Who is this? Covert. Listen. Covert Supreme said, I clubbed at the iconic tunnels. Okay, that's what's up. The iconic tunnel. It has to be the tunnel nightclub, right? I think it has to be. Okay, let's get into this. Also, Covert Super Pro said, what the F? I was at Jay-Z and Friends 2013 Staples Center. Okay. And you're at the Staples Center. Was you talking about Jay-Z and Friends? Was that like, did Jay-Z have a pop, Kid and Friends? Okay, so hold on. We'll get back to that because I think you have a point there. Hold on. Thank you so much, Covert Super Pro. Now get this. We get into some real mess. Part 3, subsection A. Or paragraph 3, subsection A. Diddy has continued his efforts to obstruct justice. As noted above, the evidence presented to Judge Tarnowski and Judge Carter amply support their findings that Diddy posed a risk of obstructing justice, justifying pretrial detention, and would be sufficient for this court to find the same. However, to the extent there is any doubt that the defendant's risk of obstruction at the time of prior bail hearings, such doubt is now non-existent. Since Diddy has been detained at MDSC, he has continued to evade law enforcement monitoring, corruptly influences witnesses' testimony, and further attacks the integrity of these proceedings. Specifically, while in custody at the MDC, Diddy has repeatedly communicated with others in ways that violate the Bureau of Prison rules and are designed to evade Bureau of Prison and law enforcement monitoring, including, as described below, as PAC numbers belonging to other inmates to make calls, using three-way calls to contact other individuals, including individuals who are not on his approved contact list, and using an unauthorized third-party communication system to send messages to numerous individuals, including unauthorized contacts. Oh my God, Diddy ain't never getting out of jail. This man is psychotic. He's never getting out of jail. Oh my God, just to run through this, right? Wow. This is crazy. So he has communicated with others in the prison when he wasn't supposed to. He's in solitary confinement. He's not supposed to be communicating with anybody else. How do you think he did it? Do you think he tied notes around like the roach's legs? They like held their legs up like little carrier pigeons and he sent them scurrying. How do you think he did it? Do you think he like literally tied little backpacks made out of ramen noodles onto the rats' backs and told them to go? And it was like Shawshank Redemption, just Stuart Little running to the jail? How do you think he did it? Literally, how do you think he did it? You said he had to think well, he can't say he had to use the bathroom. Do you think he was carving messages into the soap and then waiting for somebody else? If you're reading this, I got $5,000 for you. Just let me use your minutes. Anyway, right? So he's also using PAC numbers belonging to other inmates. So when you're an inmate, when you can make calls, because you get like a certain amount each month, they give you a number to dial in so they know it's you, and then you use it. Diddy's so stupid though, because whenever you use a phone in the Bureau of Prisons and you type in the PAC number, a camera recording from somewhere in the room automatically starts not just filming you over the phone, but starts filming you to make sure that the person whose minutes that are dialing in is the same person and people aren't trading off minutes. All of this was monitored. Diddy knew it was monitored. Diddy's lawyers knew it was monitored, and he still did it. What does that say? He is a menace to society. On top of that, he contacted individuals who are not on his approved contact list. And you did third-party calls to people that were not on your three-way calls on your contact list. And you use unauthorized third-party communication system to send messages to numerous individuals, including unauthorized contacts. That means that Diddy had a cell phone in jail. And he was texting people. And this mofo really thought he was going to get away with it. And the whole time, the whole time, the government's just sitting there like this. The whole time, they sitting up there just looking at him, literally reading the messages. The whole time. Diddy is an idiot. And his lawyers are idiots because you knew they were watching you. But the fact that you thought that you were going to outsmart the Bureau of Prisons, get this, they actually give an example. When an inmate enters federal custody, he is generally permitted to communicate with out-of-custody individuals, including friends and family members. To do so, inmates provide a contact list, which includes the individual's name, phone number, and email address. The Bureau of Prison staff must approve individuals on the contact list, and inmates are not authorized to contact individuals who are not on their contact list. Additionally, telephone calls and emails to non-attorneys are monitored by the BOP to ensure that the messages do not jeopardize the public or the safety, security, or orderly operation of the facility. When inmates make telephone calls, they're required to use a PAC number or phone access code that is connected to their unique Bureau of Prisons registry number. Inmates access email using the TrueLinks system, which is operated by a company called CoreLinks. TrueLinks is a fee-based system that inmates must pay for to send and receive messages using TrueLinks. Okay, thanks for telling us that. Let's get back into this. I appreciate that. Also, they did three-way calls. So that means that Diddy called people on his authorized list. And then the people on his authorized list would make three-way calls to call unauthorized people. And Diddy didn't think the Federal Bureau of Investigations was listening to him. Okay, sure. Why not? Why not? Why not? Oh, God. Other inmates' PAC numbers. The government has reviewed dozens of recordings at the BOP jail calls in which Diddy uses telephone accounts of at least 8 other inmates, which is against BOP regulations. Seemingly to avoid law enforcement monitoring, Diddy uses other inmates' PAC numbers to make phone calls to both individuals on the defendant's approved contact list as well as other individuals who are not on the approved contact list. To obtain the access to other inmates' PAC numbers, the defendant directs others to pay the inmates, including through payment processing apps and BOP commissary account deposits. The defendant knows this is against BOP regulations. At the offset of each telephone call, the inmate is prompted to enter his PAC number, after which an automated recording announces sharing of PAC numbers is against BOP policy and subject to disciplinary actions. So the government, that's the thing with Diddy, he's so stupid and thinks he's so smart. I would actually be worried that I was getting away with it because the government is looking for this. And they literally let you commit these offenses and they were monitoring everything just so, one, you can get comfortable, two, they can see who you're intimidating, and three, they're going to bring it up at your bail hearing. Dummy. Anyway, three-way calling. Diddy also frequently instructed individuals whom he contacts by telephone, including family members and attorneys, to add other individuals via three-way calls. His attorneys did this? Yo, his attorneys were helping him make three-way calls? This practice is not authorized by BOP as it helps conceal the identities of contacted individuals. The government has reviewed multiple calls in which Diddy has instructed others to dial in third parties, including members and associates of the enterprise and individuals who are not on his defendant's contact list. Let's get into the unauthorized messaging services. In addition to following BOP rules regarding phone use, Diddy also uses non-authorized third-party messaging service called Contact Me ASAP to obscure his communications. The defendant appears to be using Contact Me ASAP accounts, using two of them. First, the defendant's BOP contact list includes a particular email address assigned to Diddy's son, which does not appear to be an account owned by Diddy's son, but instead appears to be an email address connected to Contact Me ASAP. Oh, Diddy, the pressure is getting worse. So let me get this straight. Diddy lied to the Department of Prisons, and he put on his contact list one of his son's emails. But it wasn't actually the son's email, and he thought the Department of Corrections would never find this out. It was, in fact, an email to Contact Me ASAP. Now, they said, according to the Contact Me ASAP website, the service purports to be an innovative text messaging service for federal inmates to communicate with loved ones via real-time messages and claims to offer seamless SMS conversion. Contact Me ASAP provides an email address for the inmate, which is then put on the inmate's TrueLink's computer. And from there, the inmate can immediately use the service to text contacts. Something tells me Contact Me ASAP is about to be shut down ASAP. But anyway, Diddy said he was contacting one of his sons through email, but it was not his son, but instead an email address associated through Contact Me ASAP. Second, Diddy appears to be using other inmates' Contact Me ASAP's account, primarily using the fake email linked to a son. The defendant has exchanged hundreds of text messages via Contact Me ASAP with dozens of individuals, including attorneys and individuals who are not on the defendant's contact list. Yo, is Diddy's attorneys going to end up getting charged? Because I'm confused. Diddy's repeated circumvention of BOP regulations, starting almost immediately after arriving at MDC, speaks volumes about his ability to comply with any conditions of release. I mean, I gotta admit, if you can't act right while you're in jail and you know they're watching you, what are you gonna do when you're at your own home? Even more concerning, however, is Diddy's use of these unauthorized methods of communications to continue his efforts to obstruct and subvert this criminal proceeding. The defendant's intentions are reflected in his own words on BOP calls with a network of family members and associates whom Diddy has tasked with executing his will. I told you I'll stop feeling sorry for those grown sons. They have an agenda. On multiple calls, often using the pack numbers of other inmates, Diddy is explicit about his intention to use public statements to alter public perception and blank. The defendant leaves no doubt the narrative he wants to blank is the potential jury pool's perception of this criminal proceeding. They said examples of these efforts are plentiful. Blah, 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 blah. Notably, Diddy continued these efforts after the court's October 2025, oh wow, after the October 25th order requested by the defense come through. Great minds think alike. I'm reading this real time if you guys haven't figured this out. Prohibiting exactly this sort of conduct. After the court entered the order, Diddy enlisted family members to plan and execute a social media campaign around Diddy's birthday with the intention of influencing the potential jury in this criminal proceeding. At the defendant's carefully curated direction, Diddy's children posted a video to their respective social media accounts showing his children gathered to celebrate the birthday. Ooh, 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 Diddy, you going down. After okay. Diddy, from within the detention center, then monitored the analytics, i.e. the audience engagement, and explicitly discussed with his family how to ensure the video had its desired effect on potential jury members in this case. Besides flagrantly violating the court's October 25th order prohibiting this kind of interference with the fair trial, the defendant's own words make clear that Diddy's intent is to improperly influence the jury pool in this criminal proceeding. Wow. So let me get this straight. Diddy asked for the gag order. The judge said no. He issued an order for everybody in the trial, and Diddy continued to ignore it. And Diddy started this shit the day he landed in jail, and he didn't think those mofos were just watching him. Okay, Diddy. They said, but that's not it. Diddy does not stop there. During other calls, Diddy makes clear his intention to anonymously publish information that he thinks will help his defense in the case. They have a whole bunch of stuff redacted, so we can't read that. Defendant's efforts to anonymously leak video favorable to his defense in this case show that he is using his so-called public relations strategy to influence this criminal case. Diddy's efforts to obstruct the integrity of these proceedings also includes relentless efforts to contact potential witnesses, including victims of this abuse who could provide powerful testimony against them. For example, on October 4th, in a call involving a defendant and one of his adult sons, Diddy says, blankety blank, oh my God, it's all redacted. So listen, because we got to have a talk before we go on. What son do you think is getting RICO charges? Justin, well, he's running some of the businesses. Christian, just because he did, do whatever his daddy calls him. Quincy, do you think he got caught up in this? I do want to say this that I think is very, very weird. I think it's very, very weird that everybody in Diddy's circle is like, oh, but the kids, let them love. But they know the play that the kids are running. So what really is the truth? How many people really are on Diddy's team and helping Diddy? I'd like to know. Don't none of them have a brain cell. Lisa Rodriguez says, cute little baby loves singing happy birthday to her daddy. That's how she'll be celebrating his birthday the rest of his life. Exactly. Happy birthday, dear daddy. Your icing taste. Happy birthday. That's what she's going to be for the rest of her life. Anyway, you better wear every birthday going to be like, collect call from Sean, Diddy, brother, love, Combs. Press 1 to accept. Baby love by that time is going to be hitting 2. I do not accept. She's going to be hanging up. Now get this. Let's get into how Diddy's a danger to others. Let's get into how Diddy is a danger to others. This is, I think, the most shocking part of the government's motion to oppose Diddy's bail. In addition to failing to meaningfully contend with the ongoing risk of obstruction the defendant poses, he also spends no time addressing the significant acts of physical violence that the government highlighted at the initial hearing, which led Judge Carter to conclude that he is a danger to the safety of others in the community, more generally by clear and convincing evidence. Indeed, as the record before this court makes clear, Diddy's longtime history of violence demonstrates his dangerousness. Moreover, contrary to Diddy's claim that the evidence is thin, right? The evidence supporting the defendant's long history of abuse, including witness testimony, communications, photos, videos, police reports, and other materials, demonstrates the strength of the government's case against Diddy, a factor considered by the court. As charged in the indictment, Diddy has engaged in physical, sexual, emotional abuse of his romantic partners for years. The defendant also engaged in acts of violence directed towards his employees and many others. Oh, his employees. Who's flipping on him? They said his employees. His employees and many others, including kidnapping, arson. Well, we know the arson is physical violence, such as throwing objects at people, throwing people to the ground, hitting, kicking, dragging, choking, stomping on, and shoving others. Multiple witnesses, including defendants of Diddy's employees and others, observed or experienced Diddy's violence firsthand. Diddy's acts of violence show there is no condition or combination of conditions that will adequately safeguard others and the community. Right? One person said, the danger, I think, is quite serious. There have been weapons around. There have been significant violence, and I also think it's significant that there has, I think, been a proffer of significant evidence of coercion of witnesses. I also find that the government has proven that the defendant is a danger to the safety of others in the community, more generally by clear and convincing evidence. They said, while far from the only example, the video of March 2016 incident at the Intercontinental Hotel, discussed at length in both previous hearings, puts Diddy's dangerousness in full display. Although Diddy's lawyers conceded that the incident was relevant to Judge Carter's determination of dangerousness, Diddy fails to address it with respect to the present motion. Instead, he repeats his prior characterization of his relationship with Cassie as complex and at times toxic, and pivots to his philanthropic endeavors and family relationships with an effort to distract. But Diddy's personal relationships and charity work does not neutralize or erase the video evidence showing the defendant punching a female victim, dragging her, throwing a vase at her, or kicking her. In sum, Diddy cannot walk away with a clear record in this case. His inability to explain away his long history of violence, including the March 2006 incident captured on film, is a fatal blow to his application for release. Diddy's extensive history of violence makes him a danger to those around him, and the safety of the community cannot be ensured short of his continued detention. Ooh. Now, get this, right? They're saying that Diddy continues to pose a flight risk. The defendant has not rebutted the presumption that there are no conditions to assure his future appearance, given the fact that Diddy faces a mandatory minimum sentence of 15 years imprisonment and a statutory maximum life sentence of imprisonment. Ooh, that's nasty work. Okay. They said the steeper the potential sentence, this is U.S. case law, the more probable the flight risk, especially considering the strong case of the government. In this case, government saying in our case, Diddy has incentive to flee. Given the potential punishment and the nature of the evidence that will be presented at trial, and has nearly limitless resources to facilitate this flight. Now, while Diddy's lawyers took steps to mitigate Diddy's substantial risk of flight before the indictment, Diddy's incentives have changed materially now that he faces the very real possibility of a substantial term of incarceration. Now, get this. They said this is when they go into detail about the new bail package, and I think this is a drag. In the face of the significant evidence that the defendant poses a risk of obstruction, a danger to the community, and a risk of non-appearance, Diddy's proposed updated bail package is woefully insufficient. As discussed, Diddy has shown repeatedly, even while in custody, that he will flagrantly and repeatedly flout rules in order to improperly impact the outcome of this case. Diddy has shown, in other words, that he cannot be trusted to abide by the rules or conditions. While the proposed conditions suggest that Diddy will have no access to telephones or internet except for calls with his lawyer, this is insufficient to ensure that Diddy will cease engaging in unauthorized or inappropriate communications through the third parties. Diddy is already doing just that against BOP regulations. If Diddy cannot abide by rules in the highly restrictive settings of a federal detention center, there's no reason he should be trusted to abide by the court's condition in a less restrictive setting. Furthermore, Diddy's proposal to restrict visitors to selected family members is also insufficient. Since being in custody, Diddy has deployed family members to carry out obstructive conduct on his behalf. As evidence in jail calls, Diddy asked family members to reach out to potential victims and witnesses, create narratives to influence the jury pool, and pursue marketing strategies to sway public opinion. His emphasis on 24/7 private security is also problematic. Diddy has demonstrated an uncanny ability to get others to do his bidding, employees, family members, and also inmates. There is no reason to believe that private security personnel will be immune. The Bail Reform Act does not permit two-tiered bail system in which defendants of lesser means are detained pending trial while wealthy defendants are released to self-funded private jails. They also said courts have been troubled in the past with the possibility of allowing wealthy defendants to buy their way out of by constructing a private jail. At any rate, Diddy's private jail proposal at best elaborately replicates a detention facility without the confidence of security such as facility installs. Moreover, the Second Circuit has expressly decried attempts like Diddy's to pay his way out of detention. Diddy's updated proposal simply does not alleviate the risk of danger, obstruction, flight, particularly in light of Diddy's inability to comply with BOP regulations and his efforts to engage in obstructive conduct while subject to monitoring in the MDC. For the reasons set forth, the defendant's renewed motion for bail shall be denied. Now, what's the takeaway from this? Besides, Diddy is the dumbest dum-dum in the whole world, and he gonna stay in jail. And at the end of the day, Diddy's undoing is only at the hands of himself. It finally caught up for himself. But let's think about this. You were acting a fool in federal prison from day one, breaking every rule you could, buying off people, doing this, doing that, right? And at the end of the day, the feds knew it from day one. You thought you were smarter, quicker, you thought you could get away with it. On top of that, your lawyers were actually helping out. Your lawyers were contacting people without their other people's counsel present. Your lawyers were help running interference. The federal government made a great case of the fact that Diddy can't be trusted. He's going to try it. But also his lawyers cannot be trusted to uphold the standards of the court because they will do anything for the money, which is anything for their clients. That's the only connection they have to Diddy, the money. They're willing to do it. The lawyer was even making three-way calls. Diddy thought he was getting away with it the whole time. The lawyers had to know that their stuff was being monitored. How did they think they were going to get away with this? On top of that, Diddy's kids are nothing but shameless pawns, patsies at best. At worst, they are willing co-conspirators. Quincy, Justin, everything we see about Diddy. You know what's even more sick? Those stupid posts they did about Kim Porter for the anniversary of her birthday. Also, Diddy was the one behind that, and Diddy was telling them how to post it. Y'all, listen. One thing I want to say is thank God for arrogant, stupid men. And thank God that Diddy finally found himself in a situation through his own actions and own arrogance. He finally found himself in a situation where he can't bribe, talk, threaten, intimidate, or harass his way out of this. The federal government doesn't fear Diddy. His arms are too short to box with God. I'm being dead serious. It looks like Judgment Day has arrived for Diddy. Now, we can argue somebody taught him maybe this, maybe that. What about everybody else? To which I say, can we worry about the mofo we have in jail first? Yes, I'm sure there are others. Yes, I'm sure Diddy wasn't doing this on his own. Yes, other people need to be held accountable. But also, and let's be real, can we put the mofo in jail that we have away? Because Diddy has proven time and time again that he will continue to do this. That he'll continue to do this. So, anyway, excuse me. And anyway, you guys, listen, all I got to say is, let me get into this. Lisa Rodriguez said, he is a danger to women, men, children, cats, dogs, fish, amphibians, bugs, and reptiles. He's a scourge. He really honestly is. Tosha Smith, what's up, Tosha? Said, Tisa, I spit out my water when you did baby love impression. Love your lives. Thank you, Tosha. And Joanne White, thank you so much for the super sticker. I really, really appreciate it. Thank you so much for the super sticker. Listen, at the end of the day, what y'all think? Listen, I'm going to do a poll. Put a 1 in the comments if you think that Diddy is going to get bail. Or if he even made a good argument for bail. Put a 2 in the comments if you think that the U.S. Attorney's Office not only destroyed Diddy, but dragged his attorney, Mark Agnifilio. Put a 2 in the comments if you think that Diddy's attorneys were destroyed in court, Diddy's credibility was destroyed in court, and also all this mess that he was doing from the NBC, it's all going to be brought up in trial and the bail hearing, if it ever gets to that. And I want to know what son was all of them. It was Christian. It was Christian. It was Keisha. It was Sheila. It was Christian. It was Justin. And it was who else? Quincy doing this on the 1 or 2. Put 1 if you think Diddy's going to get away with this. Put 2 if you think it's over for Diddy. Or put 3 if you're like, you think it could go anyway, because we've been living in an upside down land. It's going to go either way. What's up, Samantha? Mix check. Thank you so much for renewing your membership, Samantha. I appreciate that. Thank you so much. What are you guys saying? Who thinks and you know what? Now Diddy got to wait for them to complete their trial. I will say that there is going to be superseding indictments, and they're going to be serious indictments. If I was Diddy and I was Diddy's associates, I would be very worried, because even if you're not going down in this indictment, you never know. The law is like an octopus, and it stretches out from all different angles. So I don't know. What y'all think? Put a 1 if you think yes, or put who said I'm convinced Diddy is, or put a 2. Wait, y'all think Diddy's going to get off with this? Let's see. Y'all really think this is going to get out? Wait, no. You guys might not hurt me. Put 1 if you think. Oh, wait, sorry. So 1 is if you think Diddy's going to get away with it. 2 is if you think Diddy's time is coming and he's not going to get away with it. And 3 if you're undecided. So 1 is he'll be out of jail. 2, he's staying in jail till trial. Or 3, you're undecided. Okay, there you go. Y'all scared me. I'm like, wait, y'all think it's 2? No, what am I missing? Because, sometimes I be thinking stuff, but I got to see what the people saying. Because sometimes y'all be knowing what you talking about. So 2, yeah, Diddy is done. But now we got to throw people's names on the list. Diddy just opened his kids up to getting RICO charges by actively participating in his criminal RICO thing. His sons, they're now involved. Who else is involved? His sons are involved. His lawyers, I don't know if they're going to get legal charges, but his lawyers have been put on notice that they are engaging in illegal behavior on behalf of their client. And get this, Mark Agnifilio used to work with the U.S. Southern District of New York, and his wife did too. So they know all the rules. So they don't even have an excuse for what they can do to get out. If Diddy was smart, Diddy should have tried to get Jay-Z's lawyer. If Diddy was smart, Diddy should have tried to hire Douglas Wigdor, Tyrone Blackburn, or even Jay-Z's lawyer. He should have just tried something a little more than what he was doing. Listen, it is. Listen, somebody said, I seriously wonder if Diddy will be pardoned by the president-elect. So you know what, I was actually thinking about that, but I'll be real. Well, Diddy better hope that he thinks that the president-elect thinks that Diddy is one of the good ones, right? But again, I feel like the president-elect won't even be bothered because he's already done in his mind enough outreach to the Black community. I mean, he has academics on his team in Little Wayne. What does he need Diddy for? And second of all, let's be real. For him to buy his way out of a pardon, there are people now, there are whole nations that would like to buy our president, whether it's Biden or Trump. It doesn't matter. There's whole nations that got more money than Diddy. I do think the most Diddy can hope for is one of his rich billionaire friends to put in a good word, either with the Biden or Trump. That is his best bet. But who knows what will happen? Again, is he going to try for it? Come on now. Look at Diddy. You think this man has any type of, but just because you try doesn't mean it's going to be granted. I think a lot of people are flipping out. Oh my God, Trump would never. Biden would never. Y'all are falling into the cult of politics. Never say never. But second of all, that doesn't mean Diddy can't try. Just because I'll never be an astronaut doesn't mean I'm not going to try to get into astronaut school. You know what I'm saying? You know, that's all I'm saying. I'm just saying. I'm just saying. Listen, I'm just saying. So listen, what do y'all think? What do y'all think? I'm actually very, very curious. What are y'all thinking is going to happen? Again, Diddy just got his sons in trouble. And this is all I want to say before I go, because I keep people was dragging us tattletales a couple weeks ago. That's it, father, teacher. What do you a loser talking about those boys? Blah, 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 blah. Call me every type of loser. We're calling us every type of loser, this, that, and thing, picking on those boys, when exactly what we said those boys were doing actually happened. And the federal government has them live in 4K on tape, and this will be up. This will be brought up in trial. So what's really good? Who is the hater? Who is the delusional one? It seems like the people that keep giving Diddy grace and keep getting Justin, Chrissy, and Quincy grace are the ones that keep looking stupid over and over again. Listen, I don't know what people have done in their lives that they actually look at Diddy and see themselves in Diddy and want to give that man some sympathy. But baby, no, I'm not saying I'm innocent. I'm sure at 2:30 in the morning, there may or may not be evidence that I pulled back around to the Taco Bell drive-thru and cursed the Taco Bell girl out because I literally paid for 20 extra fire sauces and she still threw in 3 fire sauces and 6 miles. And then when I came back around, said, oh, well, we're out. There may not be proof that I cursed somebody out at 2:30 in the morning. Yes, I'm an angel. But baby, you ain't never going to find any weird level Diddy mess in my background or any of your guys' background. So now the people that defend Diddy, that see themselves in Diddy, I'm looking at them like, what the hell have you done in your life that you see yourself in them so much that you want to provide them with grace and understanding besides what a logical manner is? Diddy is not acting like an innocent man. What does an innocent man act like? I don't know. But I'll tell you one thing, he is not acting like a man that has any type of integrity, will respect any rules, or will do anything. And the fact that he just literally bought his children into this RICO mess, yeah, okay, Diddy. Okay, exactly. They're not boys. They are grown men, 30, 33, and 26. Just because they have no income, well, meaningful ways of income outside of their daddy, just because they still literally like ride their daddy's coattails, and just because they literally follow their daddy even to hell, well, baby, if you follow them into hell, the devil is not going to send you back. They're going to let you into hell. Those kids need to remember that. You following this man to hell. Hell is not going to turn you away at the gates. Follow him in the hell. Literally, see what you're going to find. Keep pushing your luck. See what you're going to find, right? Listen. Again. Listen. I just don't understand. I'm just saying. Can anybody tell? I don't literally. Okay, I cursed out the Taco Bell drive-thru attendant. I am sorry, attendant. I did not call the customer service line. I kept the conversation between us. I was gypped for my 20 fire sauces and she had a nasty attitude. Again, could I have handled things better? Yes. Will I ever be subpoenaed or involved in a sex trafficking trial? I hope not, because anybody can become a victim. I mean, me being a perpetrator. Hell no. Will anybody in my family ever be called for that? Hell no. And people that think that actually is in the realm of conversations, we need to start looking at Diddy defenders a little strange, literally, and start like while that when they Diddy defenders in your neighborhood, when they leave for work, go and like knock on the basement windows and say, hello, does anyone need help? And see if somebody doesn't scream back. I'm just saying, I don't know what bodies they got locked in the closet. I don't know if any lady of the nights have been disappearing. Go knock on your neighbor's basement windows and just say, do you need help? Knock once and see if you don't hear a knock back on that wall begging for help. I'm just saying. Listen, I'm just saying. Listen. Who said if there's any country we could relocate when who takes office? I ain't going nowhere. My ancestors built this country, baby. We're gonna have to work something out. We're gonna have to come to an agreement. My ancestors built this country, and I ain't leaving nowhere. Please, no. We're gonna have to come to an agreement. That's all. Anyway, let's get out of here. Anyway, y'all, listen. Listen, let's not turn this into politics. Let's stick to the monster at hand, okay? Diddy's willing to try anything. He's willing to sacrifice anyone. He sees nothing but anybody else's child. I really feel sorry for his daughters and the grown men that are now wrapping around him to help him. Well, we already know what that is. I will say, interesting enough, Chase didn't participate. She stayed right in school and said, happy birthday, daddy, on film. Chase wasn't a part of that mess. Did she even repost it? Or maybe she was. I don't know. We're going to see. We're going to see. Anyway, listen, y'all. Let me go. For any of you joining this late, I'm going to break up this live into little parts so you guys can like watch it if you can't sit through the whole live. They'll be up later on tonight or tomorrow morning. And I'm also going to post a few more videos before I go. Anyway, y'all, thank you for watching. All right. I will talk to y'all later. Bye.